This judgment is about costs, in particular whether the system for the recovery of costs in civil litigation, which existed in England and Wales under the Access to Justice Act 1999, is compatible with the European Convention on Human Rights, which in Article 6 protects the right of access to a fair trial, and in Article 1 of Protocol 1 protects the right to possessions. The statutory arrangements governing costs have in most cases now changed by reason of the Legal Aid, Sentencing and Punishment of Offenders Act 2012, LASPO. But the present issue remains of importance for some old and current cases. Because of its importance, permission was given to the Attorney General, the Secretary of State for Justice, and other interested bodies, including the Asbestos Victims Support Group Forum, the Law Society, and the General Counsel of the Bar, to intervene to make submissions. The appellants are the owners of a bungalow in Suffolk. They brought noise nuisance claims against the first and second respondents, who were operators of a nearby motorsports stadium and motocross track. The appellants won before His Honour Judge Seymour. They lost in the Court of Appeal, but they won finally before this court by its judgment dated 26 February 2014, reference 2014 UKSC 13. We restored Judge Seymour's order that the appellants should recover 60% of their costs at trial, and they now also have orders for costs in their favour in both appeal courts. The appellants' base costs at trial were some £307,000, 60% of which equals some £185,000. But the appellants' lawyers acted on their behalf under a conditional fee agreement, a CFA, in other words, on the basis of no win, no fee, which makes the respondents potentially liable for a further 60% of a success fee of £2,015, that is £129,000. Thirdly, the respondents are also potentially liable for an after-the-event ATE premium for insurance, which was taken out by the appellants to guard against the possibility that they might lose the proceedings instead of win them, as they in fact have. In total, those three sums, 60% of them, amount to some 183,000. No, I'm sorry, that's the wrong figure. In total, they amount to some £305,000. And on top of that, no, I apologise. That last figure, the third figure, is 60% of 305,000, in other words, £183,000. The respondent's exposure in respect to the trial alone is thus nearly £500,000. On top of this will come exposure in respect to the appellant's further base costs, success fees, and ATE premiums in respect of the appeals to the Court of Appeal and to this court. And those are claimed at around £660,000. The respondents do not challenge their liability subject to assessment by a cost judge for the base fees, but they submit that their potential liability for success fees and the ATE premiums under the 1999 Act and the rules and practice directions made under it infringes the Human Rights Convention. By a majority of 5-2, the Supreme Court holds that the cost regime under the 1999 Act is compatible with the Convention. Lords Neuberger and Dyson, with whom Lords Sumption and Carnworth agree, give the joint leading judgment, and Lord Mance, with whom Lord Carnworth also agrees, gives a concurring judgment. Lord Clark dissents, and Lady Hale agrees with him. Lord Neuberger and Lord Dyson note the key aims of the 1999 Act scheme. First, to contain the rising cost of legal aid. Second, to improve access to the courts for members of the public with meritorious claims. And third, to discourage weak claims. The scheme deliberately imposed the costs of all CFA litigation on unsuccessful defendants as a class. Instead of placing the burden on the legal aid fund, legal proceedings were to be funded by a party's lawyers who would undertake the work on risk in exchange for a potential success fee. And if the proceedings were successful, the burden of the success fee would be transferred to the losing party. The scheme had a legitimate aim, namely making the widest public access to legal services for civil litigation funded by the private sector. The key question was whether the scheme was proportionate, in particular in the light of, firstly, flaws in it identified by Lord Justice Jackson in his review of civil litigation, which led to LASPA, that is the 2012 Amending Act, and led to the European Court of Human Rights holding in MGN versus UK, 2011, 53 EHR 5, that the scheme was incompatible with Article 10 of the Convention. Second, in the light of the imposition by the scheme on a subset of losing litigants of the costs of funding other unsuccessful cases which did not involve them at all. And thirdly, whether it was proportionate in the light of the cost practice directions which required base costs, uplift, and ATE premium to be assessed separately for reasonableness and expressly disallowed any overall reduction on the ground that the overall total appeared disproportionate. MGN against UK concerned a balancing of Article 10 and Article 6 rights and was, in the view of Lord Neuberger and Lord Dyson, of a different character to the present case. As to the flaws identified, the third, the chilling effect of a regime which could drive parties to settle early despite good prospects of a defence, was relevant, but the issue was not whether the 1999 Act scheme had flaws, it was whether it was a proportionate way of achieving the legitimate aim it pursued, viewed overall. The Court should give considerable weight to informed legislative choices in circumstances where the authorities are seeking to reconcile the competing interests of different groups in society. The European Court of Human Rights had itself recognised that a regulatory scheme may be compatible with the Convention, even if operating harshly in individual cases. The scheme followed the withdrawal of legal aid and was made after wide consultation. There was no perfect solution to the problem of how best to enhance access to justice in such circumstances. Under the current LASPO scheme, the present litigation would not have been viable at all. The financial position of the paying party had never been a relevant factor in determining the assessment of reasonable and proportionate costs. The scheme as a whole was rational and coherent and was not incompatible with Article 6 or with Article 1 of Protocol Number 1. Lord Mance adds in his judgment that the respondents' interest in being able to defend themselves at a reasonable and proportionate cost engages a balancing exercise when set against the appellant's interest in access to justice, but that the 1999 Act scheme had been in force for over a decade, during which it had been repeatedly endorsed by appellate courts. Litigants such as the appellants had, together with their lawyers, acquired a legitimate expectation that the scheme would be enforced. Legal certainty, consistency, and those legitimate expectations all therefore militated in favour of upholding the 1999 Act scheme in the current circumstances, although it could still be challenged as against the United Kingdom in proceedings in Strasbourg. In his dissenting judgment, Lord Clark concludes that the 1999 Act scheme was disproportionate because it didn't treat all defendants in the same way, but chose a particular class of defendants to impose liabilities on them far beyond the bounds of what was reasonable or proportionate. The scheme was, in his view, discriminatory in a way that was incapable of objective justification.